Fixed.
Sorry, please call the list. No further mentioning. Sorry.
Correction.
Yes, yes. Mention on Monday. Yes, please call the list.
Item number 1.
Related to murder. Yesterday you mentioned this matter.
Yes.
Yes, yes. Issue. Learned advocate representing the petitioner submits issue involved in this writ petition relates to madrasa education. Writ petition stands released due to want of determination and be placed before the bench having determination. You are for the state? Yes, give your appendix.
Item number 2.
Item is to the petitioner. I'm led by Mr. Ujjwal Rai. It's on his legs, my lord. Previously, there was a direction to serve. Service could not be completed by the
Yes, please do case if you are ready.
affidavit of service. Here, my lord, assistant teacher. Firstly, the online application was made, which was turned back by the school, my lord. And thereafter, an offline application has been made, and nothing has been done after receipt of the application.
But who is appearing for the commission when you have effected service?
My lord, on the earlier date, my lord, state was represented. Was served on 4th July.
Yes, I am asking who is appearing for the commission.
That I am not aware, my lord.
When you have effected service in terms of the order dated 7th August 2025.
I have posted it on 8th August.
Yes, when you show me the service,
Yes, sir.
when it was served upon the commission.
It was when everything has been served, my lord, on 12th and 11th of August.
Show me service upon the commission.
Sir, I have to check the ID. Number 7 delivered on 12th August.
Is it whether it is affirmed? Your affidavit of service?
Yes, ma'am.
Commission was delivered on 12th August.
Page 7.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. In spite of service of notice, respondents are not represented. Stop. In spite of service of notice, in spite of service of notice, respondents are not represented. Stop. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon Mr. Sunit Kumar Rai, learned advocate, who represents West Bengal Central School Service Commission, who normally represents West Bengal Central School Service Commission. Stop. Let notice be also served upon the learned advocate representing the state respondents. Stop. List the matter under the same heading on. List the matter under the same heading for further consideration on 16th September 2025.
The only thing is the school is required, but
You have served upon the school.
served, yes.
Next. Third notice, you need not affirm affidavit of service upon the state respondents and the commission. Mr. Rai, I have engaged, acha, আর একটা line add করে দাও. Concerned authority of the commission is directed to, is requested to regularize engagement of Mr. Sumit Kumar Rai on behalf of commission. Yes, next.
Item number 3.
For the statement.
Obtain instruction.
And for the petitioner in this matter, my lord, I am led by Shogoto Mitra, my lord. My lord, in this matter,
Yes.
on the last occasion, lordship has directed order dated
Last minute.
first month.
Yes.
My lord, I have the report, my lord. My lord, as per the DI, my lord, the headmaster of the school, there has been deliberate inaction on his part to form the managing committee.
That is separate thing.
My lord,
Whether you have issued no approval or not.
for the salary, my lord.
Yes.
My lord, as per the DI, it is not possible to approve the salary without the managing committee.
For headmaster, for the fault of the headmaster, petitioner will suffer. What you are submitting? A man who is working, he will suffer for the headmaster.
My lord,
Then I have to direct the DI to remain personally present.
my lord,
Call the government paid
my lord.
pass over.
Item number 4.
Have you served notice?
My lord, in terms of my lord's order, my lord, on 14th August, I have posted, but up to 21st of August, track report is available, like it is dispatched, it's not late. Up to 21st August.
Then you complete service because your grievance is against the school authority.
The school issued the NOC, undoubtedly.
Whether it has been,
My lord's order is there, but since my lord's order, it needs to be complied.
why school is not forwarding it, that has to be ascertained from the school authority. At least service has to be complete.
Exactly, since my lord's order.
Take back your affidavit
Yes.
service. Learned advocate representing the petitioner submits service of notice upon respondent number 6. 6 is not complete. and accommodation is paid for. Next paragraph. West Bengal Central School Service Commission and board are represented by learned advocates. Next paragraph. List the matter under the same heading on 16 September 2025. In order to enable the learned advocate for the petitioner to complete service of notice in terms of the order dated 11th August 2025. Next.
Bye.
Item number 5.
And for the state, my lord, led by Mr. Siddiq Purban.
তিনটা পাস ওভার না তিন পাস
Find this short password.
Yes, deficit code fee filed. Deficit code fee was deposited. Yes.
My lord, kindly short.
Why?
I have not advocated on record, advocate on record on the board.
Issue.
One short.
As per report of the section officer, Mandamus section dated 4th September 2025, which is addressed to the court officer. Full designation which is addressed to assistant court officer of this court. It is found that deficit court fee was deposited after order was passed on 13th August 2025. Stop. Let said report dated 4th September 2025 be taken on record. Next paragraph. Today, on behalf of petitioners, accommodation is paid for. This is the matter for further consideration under the same heading on 17 September 2025. Next.
Item number 6.
Yes, call the passover matter. Call the passover matter.
Item number 3.
Last professor lordship directed take instruction why the
No, not to take instruction, but to take steps so that the
Lordship.
salary can be released.
Lordship.
Not for taking instruction.
So I-
What was the order? Order was very specific, Mr. Rai. The Mr. Rai and government Peter prays for 7 days time, which would enable the respondent number 5 to take steps in order to release salary in favor of.
Lordship. I already take instruction. The problem is otherwise. The school education department send the nominee and also the person interested person also send the nominee for formation of the managing committee. But the headmasters of the school, headmaster, not ready to form the managing committee. As a result, the headmaster is already so cost. In this scenario, the DI is unable to approve the appointment. If Lordship directed, the DI is ready to.
Why court will direct? Please appreciate,
Lordship,
please
please.
appreciate the situation that the petitioner is not at fault. Petitioner was
No.
appointed in terms of the direction of the West Bengal Board of Secondary Education. Now it is not within the hand of the petitioner to take steps for formation of or reconstitution of the managing committee. So therefore, if there is a tussle going on in between the DI, concerned DI Bakura and the headmistress of the school, for which for that why petitioner will suffer?
No. Lordship, the DI several occasions wrote the letter to the headmaster to reconstitute.
Very well, take steps whatever you can in accordance with law against the headmaster. There is no issue.
The so has
But
already been issued.
very good. But at the same time, you grant approval of appointment so that the petitioner can get salary.
DI is ready.
Court will not direct.
No, ready. DI is ready to release the salary today.
Very well, do this.
But approval of the salary will be get later on after formation of the managing.
No. Why petitioner will suffer? Petitioner has been transferred in accordance with law.
The my Mr. DI is ready to release the salary.
Tell DI to immediately release salary on granting approval. Otherwise, I will direct to stop salary of your DI. There might be it may be found that headmistress has wrongly not been able to form the managing committee or reconstitute managing committee. For that, why the teacher will suffer who is on
No.
transfer?
Never suffer. The scenario is that the government already sent the nominee.
You take steps against the headmistress.
The DI cannot appoint the DDO in this scenario.
Take steps against the headmistress.
Lordship,
But
already
don't put the petitioner being the teacher of the school in a disadvantageous position. So therefore, immediately issue approval memo and release salary in favor of the petitioner. Otherwise, I will direct the DI to remain personally present before this court to face the music.
Yes. Lordship, DI is bound to comply the Lordship's order. Today morning he is ready to release the salary. But unfortunately, for
Issue.
the act of the headmistress,
Issue.
he cannot do this.
Matter is taken up for consideration. Matter is taken up for consideration in terms of the order dated 1st September 2025, when Mr. Amitabh Broto Rai, learned government pleader, appears on behalf of the state respondents and submits that in spite of all steps taken, headmistress, not headmaster. Yes, headmaster or headmistress.
Headmaster, my lord. Headmaster.
Purulia Netaji Vidyapith
My lord.
is not Bakura DI.
Yes, it is
This
not-
You know nothing. What my lord you are saying. It is Madhubon Goenka Vidyalaya HS.
Madhuban Goenka Vidyalaya.
Bakura, yes. Why you are saying yes?
My lord.
You haven't read the brief.
My lord, I- Page 29.
হ্যাঁ কি বলছিলাম? Headmaster of Madhubon Goenka Vidyalaya Bakura motivatedly till date has not taken steps has not taken initiative for reconstitution of the managing committee of state school, Madhubon Goenka Vidyalaya HS Bakura করে দেবে, of state school. As a result whereof administrative impasse is continuing, which prevented the district inspector of schools AC Bakura, being respondent number 5, from issuing approval memo in favor of the petitioner. Stop. Due to absence of approval memo due to absence of কেটে দাও for not according approval in favor of the petitioner on his transfer to said school. When you joined the present school,
My lord, on fifth
March
March
2025.
2025.
হ্যাঁ কি বলছিলাম? Petitioner is not getting salary after joining the post of assistant teacher in after joining the post of assistant teacher on 5th March 2025. Next paragraph. Due to failure on the part of the headmaster of said school to reconstitute managing committee, petitioner ought not suffer. Now, there is no illegality in transferring the petitioner from previous school to the said school with effect from 5th March 2025. And as such, response number 5, as such, District Inspector of Schools, LC Bankura, District School LC Bankura being response number 5, is directed to issue approval of appointment in favor of the petitioner on compliance of necessary formalities by 7 days from date, and release salary, monthly salary including arrears, by 4 weeks from date. So, next paragraph. Writ petition stands disposed of urgent xerox certificate.
Deeply obliged, my lord.
Next.
Item number 6.
On behalf of the petitioner. The last petition on. My lord, there was a direction, my lord.
Just a minute, just a minute. Yes.
My lord, in compliance with my lord's last order, my lord, the DI have submitted this, my lord, only that,
Where is the
it
medical?
could, my lord, it could not be found, my lord. So a 3 means committee has been, my lord, constituted by them, but till, my lord, it has not been found, my lord. So a general
What
DI,
basis?
my lord,
DI,
my lord, the application is there, my lord. If my lords may kindly see.
application is not, court wants to see the medical report.
My lord, a general diary, my lord, has been already lodged relating to that,
What
your
is the
lordship.
test you would like to take, but where is the medical report?
My lord, an application made has been to the CMHO.
Your DI
No, it was there,
allowed
my lord.
transfer application.
My lord, may kindly see this. This communication was there.
It will be stated therein that in spite of effort, this report was not found.
My lord, it
So
is there.
but the court directed then why, how DI?
My lord, only 7 days. My lord, 7 days time has been, my lord, prayed for the my lord, on behalf of the respondent number, so that, my lord, it can be found, because another application was made to the CMHO for the, my lord, medical report, since it has not been found. It is there, my lord, with this application is also there.
Your previous application is dated?
It was dated 5
Page
3
44.
It is page 44, my lord.
Your previous application is dated to 3rd of March 2022.
3rd of March 2022. It was forwarded to the head of the institution by 5/3/2022, my lord. Yes, your lord. It's 3/3/2022.
No, that is local arrangement has been done at head of the institution.
Serial number 10. 10, 6/10/2021.
No, the application on health ground.
Serial number 10, 6th of October 2021.
That was my first one.
First application.
That was first application.
And subsequent applications were on the ground of distance.
Subsequently, on the ground of distance, my lord.
No,
Single
3rd of March 2022, single teacher.
single teacher.
Single.
On the ground of distance, my lord. Otherwise, my lord, in medical ground, there will be no bar. But subsequently, my lord, petitioner made an offline.
But this medical ground application dated 6th October 2021 was sent back to the school. It was not allowed.
Not allowed
Not
by the district inspector of school.
Thereafter, all applications were made. No, first application is dated 6th October 2021 and second application is dated 3rd March 2022. First application was disallowed, second application was also disallowed.
Subsequently, petitioner made another application
offline.
Offline.
NOC already
Issued. That is on what ground?
My lord, that is on medical ground. When the petitioner made the
But once your medical ground application has been disallowed,
I tell you, lordship, my lord.
in the meantime, how your second application, which has been made in the meantime, is found to be applicable?
I tell you, lordship, when he applied in the Utshruti portal, my lord, he was suffering from some spinal cord issue. Later on, when he applied in this offline mode, my lord, now presently he is suffering from ischemic heart. It is very difficult for him to travel 41 kilometer up and down, total 82 kilometer every day. It has been advised to him by the doctor that he should avoid long, prolonged journey every day. That's why he made this offline application, which is at page number 50, my lord. And the no objection was issued by
But
the.
no objection at page 54 is blank.
No, this 55A, my lord.
It is dated, this application is dated.
Application is dated 21/3/2025.
Yes, give me your report. কোন ঢুকেছে? দিন তো হয়ে গেছে। আন শুনছিল। আন এসছে প্রথম দিকে যারা গেছিল তারা পেয়েছে। What your DIS said Medinipur certificate?
Yes, my lord, there's a typographical error, my lord.
What is Medinipur certificate?
Last thing জেনেছি। এই ফান্ডে সেটাতে আমাদেরও কি কভার হবে না?
Now, since the nature of element is changed, let there be direction to re-examine the petitioner. Self-medical ground application. And DI is in a difficulty because it is not on record as on date as it appears. Issue. In terms of order dated 14th August 2025, a report is filed by the District Inspector of Schools AC, Paschim Medinipur, being respondent number 9, dated 3rd September 2025, and same is taken on record. Next paragraph. On perusal of report dated 3rd September 2025, it appears, in spite of making effort to find out medical certificate which was obtained based on previous transfer application of the petitioner. Dated 6th October 2021. Same was found not available on record maintained in the office of the respondent number 5. No, this one 5. Respondent number 9. Respondent number 9. Stop. Next paragraph. Learned advocate representing the petitioner submits at present petitioner is suffering from different ailment. Therefore, petitioner is required to be medically examined again, since an offline application is made on 21st, since an offline transfer application is made on 21st March 2025, and school authority where petitioner is presently working has issued no objection, quote unquote, no objection, on 26th March 2025. According to the petitioner's previous medical report, if found, that may not be found relevant, since petitioner has made offline application dated 21st, offline transfer application dated 21st March 2025, since he is suffering from different ailment. Next paragraph. Whether the application is lying before the DI, whether the school has forwarded it.
No, it was forwarded.
Yes.
I have to take instructions, Miller. I have to take instructions.
You have not stated in your writ petition? Have you served upon the school?
Yes, I have served upon this.
When?
At page 57, is the managing committee resolution. Relevant to first para, last item.
Right. Next paragraph, it is also found that the managing committee of the school where petitioner is presently working, by adopting resolution on 26 March 2025, decided to permit the petitioner to take transfer on medical grounds. Stop. Next slide. Therefore, teacher in charge of Shamchandpur Sitaram Jeev Vidya Mandir, Sitaram Jeev Vidya Mandir within bracket HS close bracket posting element, being response number 10, is directed to forward transfer application of the petitioner dated 21st March 2025 in offline mode to the respondent number 9 by fortnight from the date of communication of this order if till date same is not forwarded. Stop. On receipt of transfer application, respondent number 9 shall obtain medical report from concerned chief medical officer of health / medical board on medical examination of the petitioner by 3 weeks thereafter. So in the medical report, TMA / medical board is required to opine considering present health condition of the petitioner, whether he is required to avoid long distance journey or not. Stop. If medical report justifies transfer of the petitioner, transfer application along with medical report shall be forwarded to the Secretary, West Bengal Central School Service Commission, being respondent number 5 by fortnight thereafter. Stop. On receipt of transfer application and medical report, respondent number 5 shall decide transfer application in accordance with law by 4 weeks thereafter. Stop. Decision to be taken by the respondent number 5 shall be communicated to the petitioner by fortnight thereafter. Next paragraph. It is made clear that suspension of portal shall not be a ground to reject transfer application of the petitioner. Stop. Next paragraph. Writ petition stands disposed of.
Item number 7. Petitioner. There was a deduction to file a report. No advance copy may be served.
Yes. Where is the learned advocate representing the state? Last occasion he appeared. Serve a notice come back.
Difficulty is, my lord, I am going to retire October. If lordship has, my lord, direct to my lord to file a, my lord, affidavit or my lord report after.
No,
vacation.
court wants to see the report. Serve a notice come back. Yes. Issue. At the time of call, state respondents are not represented. Next way. Where is Shuman Vishas? Land advocate who represents state respondents. Court directed to file a report. DI was directed to file a report. Inform him. কি বলছিলাম? At the time of call, state respondents are not represented. Stop. Learned advocate for the petitioner is directed to serve notice upon the learned advocate representing the state respondents by 11th September 2025. Next paragraph lists the matter under the same heading on 17th September 2025. Stop. Next paragraph, it is made clear if on the next date District Institute of Schools AC South 24 Parganas being respondent number 5 being respondent number 5 or being respondent number 4 being respondent number 4 being respondent number 4 does not file report in terms of the order dated 18th August 2025. Appropriate order shall be passed for ensuring presence of respondent number 5, presence of respondent number 4 before this court on the next date. Next. Communicate this order by day after tomorrow.
Item number 8.
My lord, I beg to appear on behalf of the petitioner in this matter, my lord. My lord, there was a direction to serve upon the school authorities. Service is complete. The period of service is there, my lord. I have only I'm paying for one indulgence, my lord. It has not yet been affirmed by course of the day. It can be affirmed, my lord. It has been delivered. It is there before your lordship. This affidavit of service.
Yes, school is represented.
Oh, very well, my lord. Very well. I could not
Last-
understand. Please, lord, my
Just a minute. Report.
Second page में paragraph 4. একজন টিচার হয়ে যাচ্ছে অপারেটর
975 teachers, students, 13 teachers.
is, but there are sufficient Bengali teachers in the school.
But what about people teacher ratio?
Is that is 13 teachers, then that will come to
75 students, 13 teachers.
575.
975.
Oh, 975. 13 teachers. 520. Yes.
75:1.
But for the subject, my lord, my humble submission is that for the subject, there are sufficient teachers.
Well,
Yes,
note that,
yes.
well, there were
After the people teacher ratio gets you will be granted, the leave is to be granted to you to make an application in accordance with law after pupil-teacher ratio is improved.
As your lordship pleases, my lord. Only one thing is that the Bengali subject will not be affected
No,
because
it's
there
not a case of single teacher, but
Yes,
it's a case of pupil-teacher ratio, poor pupil-teacher ratio.
yes, my lord. Yes.
They are not saying that it is a case of single teacher.
Yes, my lord.
Yes.
Another issue, my lord. This school is under administrator since 2016, and my lord, here in the array of party, managing committee has been made party. It is completely erroneous addition of party because 2016 onwards it is under administrator. Under administrator is having this, and it is a responsible school as of now. So it is converted into a responsible.
That's why I have directed a DI to file a report. In terms of the order dated 18th August 2025, District Inspector of Schools AC Purbo Medinipur, being respondent number
Five.
5, has filed a report dated 1st September 2025, and same is taken on record. Next paragraph. On perusal of said report, it appears the roll strength of the school for classes 5 to 12, for classes 5 to 12 is 975. Whereas at present 13 teachers are working, including petition. Stop. It is also disclosed in the report based on letter dated 27th August 2025 of the headmaster of the school that there are 24 sanctioned teaching posts
20% something.
in the school, but 11 posts are lying vacant. It is submitted that due to poor pupil-teacher ratio, no objection was not granted on transfer application of the petitioner in order to permit the petitioner to take transfer. Next paragraph. School authority is represented by Mr. Prasad, learned advocate, who has submitted that administrator is functioning in the school from 2016 and there is no managing committee. But administrator has not been arrayed as party respondent. Stop. Therefore, writ petition suffers from defect of parties. Next slide. Since application for transfer was made by the petitioner on the ground of distance and not on medical ground, considering the transfer rules, it is found poor pupil-teacher ratio is relevant consideration in permitting the applicant teacher to take transfer. In the present school, against 975 teachers.
Student.
In the present school, against 975 students, 13 teachers are working. And as such, pupil-teacher ratio does not permit transfer of the petitioner on the ground of distance. Next paragraph. Hence, no relief can be granted to the petitioner, and same stands dismissed. Next paragraph. However, this order shall not preclude the petitioner to make application for transfer in future in accordance with law if pupil-teacher ratio is improved.
Instruction we kept in record.
Yes, that I have stated. The report is taken on me.
Grateful to Lordship.
Next.
Item number 9.
No, I am for the school authority. Respondent number 6.
Well, I'm for the state, before entering into the minutes, the district school is within the jurisdiction of district inspector of school, Barakpur. But he has made only district inspector of school, not 24 Barashat. Barakpur is required to be added. And
Because the school comes under the jurisdiction of
Yes.
district inspector of schools, AC,
Barakpur. And page 21, their legal notice also transpires that they have issued notice to the district inspector of school, Barakpur.
issue.
Not my report should
Client advocate representing the state respondent submits
State manager.
report ache.
State.
that the school where husband of the petitioner is working,
Husband of the petitioner.
the
I have
school where husband of the petitioner is working comes under the jurisdiction of district inspector of schools, within bracket AC, close bracket, Barakpur, and Barakpur, but concerned district inspector of schools AC Barakpur, North 24 Parganas, has not been arrayed as party respondent. Next paragraph. So presence of DI Barasat is not necessary.
I don't know, let it be given. I don't know why Barasat is being made. I don't know.
My last friend is correct.
It's not necessary. Present, you are the teacher.
Yes, my lord.
So presence of DI Barasat is not necessary
No,
because your school comes under Barakpur.
Barakpur.
Next paragraph. Leave is granted to the client advocate for the petitioner
Oh,
to amend the cost title and describe the respondent and describe the respondent appropriately against respondent number 5. And array district inspector of schools AC Barakpur, North 24 Parganas as respondent number 5. So you will correct respondent number 5.
My lord.
Strike it out, Barasat, and against respondent number 5, include DIAC Barakpur. Stop. In course of this day, stop. Next slide. After such amendment is carried out, stop. However, service of notice upon district inspector of schools AC Barakpur is dispensed with since state respondents are represented by learned advocate. Next slide. Next, learned advocate for the petitioner, learned advocate for the state respondents is directed to obtain instruction from district inspector of schools AC Barakpur by 10 days from date. Stop. Next paragraph. List the matter under the same heading for further consideration on 28 October 2024.
My lord, I am for the school authority. May I be permitted to submit my report?
Nothing today. I have not called for any report.
May I amendment
No. Not at this stage.
Item number 10.
Then, Lord, I am for the petitioner. Lord, here the on previous occasion, Lord, my lord directed me to effect the service of notice upon the school.
With a private respondent in person. You know. Yes.
Lord, here in the petition, Lord, the point is raised. Lord, this petitioner is the Lord, the private respondent is a teacher of a Lord, the concerned school. He has been arrested.
Just a minute. Your service, affidavit of service.
But the for the school is concerned,
No.
Phone number, sir. Yes,
But
affidavit of-
sent but not affected. I sent it but not affected. Lord. I
Who is for the
find it.
board?
the name of the school and the
But
is not
For this,
name of the school and the teacher concerned is not
not
revealed.
But here last
reveal.
occasion Lordship directed only the victim name.
Lord, no.
But here Lordship
Lord,
read the petition,
I have
the all of the.
I brought all the notification on previous occasion. My lord wanted to know why I have strike out all the name of the father's name, victim's name, and other particulars. Where is the rule? Where is the notification? Lord, I have brought all these notifications. Lord, there is a the notification issued by the government of India Ministry of Home Affairs, and our High Court notification is also there. Lord, in view of that, Lord, the criminal rules and order has also suffered an amendment. Where my lord has it has been categorically stated nothing can be even remote the disclosure shall not be made so far as this offense under section Lord 376.
What was the issue?
Lord, the husband of the present petitioner was a teacher of the concerned school. He was arrested in connection with the offense committed under the POSCO Act, and he is in custody. Lord, that is why, Lord, in accordance
Husband of the petitioner.
husband of the petitioner, and victim is the daughter. Victim is the daughter, and that is why, Lord, he has been still his husband is in custody. Lord, the representation has been submitted for initiation of the departmental proceeding in accordance with law. Representation remains silent. That is why the present petitioner was filed. On previous occasion, my learned friend asked this same point, why this has been strike out and so and so, and my lord asked me to submit the all notifications. Our High Court notifications, Ministry of Government of India's notification, and the Central and the criminal rules and orders also.
Opinion.
এই প্রশ্নটাই
অক্টোবর পুজোর পর ভাইফোঁটার পর Now you want initiation of disciplinary proceedings against the teacher.
I'm Lord,
Now, what is the present position so far trial is concerned?
Lord in custody. Lord, the trial not commenced.
completed.
Evidence is going on. And Lord,
Now, if ultimately the accused is exonerated, acquitted,
Lord, if accused is
because there is no separate charges. So on what basis initiation of proceeding is to be, because initiation of proceeding has to be rest on the outcome of the trial, criminal trial.
Lord,
If criminal trial ultimately after completion of trial, if criminal court acquits the accused,
Lord,
then what will happen?
Lord, my respectful submission, the moment he has been taken into custody beyond the 48 hours.
No, but because that is not in connection. That is not in connection with discharge of duty of the husband as teacher.
Lord, the moral turpitude.
Yes, but what will happen
Lord,
if in POCSO cases, if ultimately there is acquittal?
But in case of the acquittal, he will be
So
reinstated.
therefore, we should wait till the outcome of the criminal trial.
But Lord, he should
At this stage,
and
court
he
cannot permit the authorities to initiate a proceedings. That can be a futile exercise.
Lord, the moment he has been taken into custody and Lord, on previous occasion, Lord, he has.
No, if he is taken into custody, if he is still in custody, he is to be suspended.
That has
And
to
this is whether petitioner has been whether the husband of the petitioner is suspended.
Yes, yes, 23rd of March
That
2025.
report I have not received.
2025.
That report I have not
Board,
received.
board is
Then
If it is suspended, suspended.
and then Lord,
But the initiation of proceeding is not permissible at this stage. Because there is no allegation in due discharge of duty of the husband of the petitioner being teacher. There's an allegation in connection with an provisions of POCSO. So now, if ultimately petitioner is exonerated, then entire exercise will be futile. Everything rests upon the outcome of the criminal trial.
And also, Lord, in departmental
Yes.
proceeding, Lord, the misconduct shall be also taken into consideration, Lord.
At this stage, nothing.
3rd March, Lord. 20 March is suspended. Only 4 months.
Then, Lord, kindly give us liberty, give direction upon the Lord, the concerned authority to initiate the departmental proceeding based upon the outcome of the criminal proceedings.
That is automatic. If he is convicted, he will lose job.
Lose job also the departmental.
That is automatic. If he is convicted in POCSO case, he will lose job. What remains?
Lord, suspension, I had no knowledge, Lord. I had no knowledge. Now, my learned friend has just disclosed before your lordship, he has been suspended.
Where is the case number?
That the case number. Lord, for the police station case number 140.
Where from you are getting it?
But the all original copy I have given to your lordship in envelope, sealed envelope, the last annex, last punch, Lord.
In the writ, from the writ petition, it cannot be.
My lord cannot, but for my lord's perusal, the sealed envelope.
এটা খোলো তাহলে। কাচিটা দাও, কাচিটা। All the informations from which victim can be identified, that should not be disclosed.
All that about the departmental proceeding is going known school name.
No, that's why these
Lord, say,
particulars are not disclosed.
Then Lord,
All the materials from which victim can be identified.
then there's a connection with the.
And we had to amend our rules, criminal rules.
That's the High Court law.
Page 20 is the
Last minute. ये खोलो। Twitter, Twitter. আইটি থেকে কেটে নাও, পরে আবার করো, নাহলে তো পুরোটাই ই হবে। তোমাদের বারবার বলি, তোমাকে ঘরে রামকে এখান থেকে নিয়ে ওইটা দিলাম, এইটা ঠিক আছে। Calcutta High Court Criminal Subordinate Courts Rules 1985, it says, Rule 713A, that no petition or application in any proceeding pertaining to offence under section 376 so and so of the Indian Penal Code as well as offences under POCSO Act filed in court shall disclose the identity of the victim. That is, the victim's name, parentage, address, or any other particulars relating to her identity. That's why school name has not been disclosed. Rightly done. That's why name of the school has not been disclosed. এটা খোলো তো।
Page 20, my lord.
Page
20, 20. Particulars of the criminal case. But I am not reading the particulars, my lord. Page 20.
This is FIR.
This is the, my lord, a charge sheet. Page 20 is the charge sheet. Final.
Page 20.
20, my lord. FIR is 15.
Page 15.
Is the FIR charge sheet is page 20.
Where is the FIR?
15, Lord.
15.
Yes, Lord. But 15 serial number 2
Charge sheet. Serial number?
offense particulars of the offense serial number 2 page 15. My lord, got it. And Lord, the chart sheet page 20 serial number 2 from top.
This page 15 is not readable. This FIR.
Lord, the conclusion of the case, my lord, will find from page 22, second paragraph.
Page 22.
Second paragraph. During investigation, I visited. Sentence starts from there.
When he was arrested, 21st March 2025.
Yes.
Tell me the date of arrest.
Date of arrest. Lord, he was arrested on Lord the page 20, 21st day of March 2025, serial number 15,
Still in custody.
still in custody. Serial number 15,
And case number,
Lord, this is the case number 140 of
14025, 20 March 2025.
My lord. Kindly consider page 35.
এই এটা অফ করে দিতে হবে।
32,000, my lord.
Oh, that you are working as a primary teacher.
My lord, petitioner, even my lord, made a representation here for extension. And that should not be.
পিআই চেয়ারম্যান সবাইকে তো করেছিস পিআই কি করবে
There was a natural death of your recommendation
Yes.
in terms of 17.3. What can be done?
My lord, I should candid before your lordship. My lord, several matter is going on, my lord. One.
Where is the prayer for extension of recommendation?
Page 20. Page 20. I'm taking
20 to 21
20, 21.
When 90 days expired? January, February, March. 19th March 2024. (2025) 19 March 25. Petitioner is working as permanent teacher. Yes, same order. এটা দেখে নিও corrections আছে। Next.
Item number 13.
My lord, 39 for the petitioner, my lord. My lord, I am paying apology, my lord, due to illness of clerk. My lord, affidavit has not been affirmed, but service is completed, my lord.
Yes.
My lord, earlier occasion, my lord, passed order for transfer of the petitioner under Utsoshi, but thereafter, the concerned authority,
When you have served upon the commission.
my lord,
My lord, earlier occasion directed for medical examination. That medical examination found he is fit.
but
She is fit, sorry. My lord, it appears, my lord, page 42.
42, my lord, that is the challenge.
He is challenging further medical examination. My lord, he is
Because, my lord,
for
petitioner
further
is
examination.
severe illness, kidney and gynecological problem that was not medically examined thoroughly not examined. My lord, I have annexed that
What is the scope on in view of this medical report?
My lord,
Because it was done as per order of your lordship.
I have annexed, my lord.
In the previous
Earlier proceeding.
My lord, I have
Page,
annexed, my lord.
page 37 of my lord's.
Please
36.
been examined before the medical expert at Apollo Hospital and
Hypertension, stable medication and seen physical fit.
Now, what do you want?
my lord, only clarification that only that she is a patient of hypertension. My lord, there is no clarification about
I am not a medical expert.
No, my lord,
The
petitioner
medical board, my lord, has constituted pursuant to my lord's order.
personally visited and treated to Apollo Hospital and Apollo Hospital.
That cannot be given any credence. Apollo Hospital's
My lord,
report. Court will consider in terms of the rules, transfer rules.
as per
Transfer rule says CMOH has to submit it. But if CMOH is report does not come in your favor, nothing can be done.
But my lord, further medical verification, my lord, kindly that annexure P9 petitioner made a representation for further medical verification that was thoroughly check out the gynecological and kidney disease, my lord. Petitioner is severe patient of kidney disease and gynecological problem, my lord. Severe gynecological problem and kidney disease, my lord.
That is the receipt.
Issue. Petitioner matter is heard in presence of the learned advocates representing the petitioner and state respondents. Stop. In order to consider transfer application of the petitioner, which was made on medical ground. In terms of order dated 8 September 2024 passed by this court on a writ petition being WPA 20262 of 2022, a medical board was formed and said medical board examined the petitioner. And said medical board examined the petitioner. Stop. On medical examination of the petitioner by the medical board, on 14th November 2024, a report was prepared, a medical report was prepared, which was forwarded to the Chief Medical Officer of Health Murshidabad by the Medical Superintendent cum Vice Principal, Murshidabad Medical College and Hospital, Berhampur. Sentence last madam. On medical examination of by medical board, copy number 24. Here, which forwarded to the Chief Medical Officer by the video memo dated 14 November 2024. Stop. Said, next paragraph, said memo dated 14 November 2024 is at page 42 of the writ petition, wherefrom it appears that on medical examination, medical board opined that though petitioner is suffering from hypertension, but she is stable at present. Though petitioner was suffering from hypertension, but he was found to be stable. But she was found to be stable and physically fit. Next paragraph. In view of medical report furnished by the medical board dated 14 November 2024, no relief can be granted to the petitioner based on transfer application made by her. Stop. Hence, writ petition stands dismissed. Next.
There is no hypertension, but not gynecological.
I am not medical expert. Sorry. Next.
Service.
No affidavit service দরকার নেই।
Item number 14.
আমি রেকর্ড করিনি affidavit। Yes.
And for the petitioner, my lord, the matter is relates to CPF to GPF, my lord. The employee was
Louder.
The employee was an assistant teacher, my lord.
CPF to GPF, what you are praying for?
My lord, I have filed an option, my lord, but I didn't receive any pensionary benefit, my lord, because the wife of the petitioner was died, my lord. And
Wife of the petitioner was the teacher.
Wife of the petitioner was the teacher, my lord.
When she exercised option?
She exercised option, my lord. Before.
Where is the affidavit of service? When wife of the petitioner exercised option?
Wife of the petitioner's husband died prior to my lord, pronouncement of the judgment and my lord, the notification. Kindly see the notification came into force, my lord, 16 July 2013. And my lord, the husband of the petitioner died.
Order was passed on Abhijit Boidya on 16 July 2013.
Yes, my lord.
Notification is dated June 2014.
My lord. So unless my lord, notification
13 June 2014.
Yes, my lord. Notification, based on notification, the employee has was got opportunity to exercise the option. but the here employee has died prior to my lord
So
notification.
then what is the scope?
My lord, scope in terms of my
Who
lord,
will exercise option?
no, exercise option, ROPA 90, my lord, the employee exercise option. But the widow of the my lord, employee was not my lord scope in terms of my lord the Abhijit Bojjo judgment. That's why my lord the Jharna Bhattacharya and my lord the Sefali Jana, the Honorable Division Bench has my lord given right. Those who employee has exercised ROPA 90 and ROPA 98, they are my lord the but the due to death prior to pronouncement of judgment, the wife has every right to exercise the option. My lord, this is the judgment. Well, this is the judgment of well, review application of filed by the state in the division bench, and subsequently 2018 2013 2023 the division bench has permitted, and based on that the other court has also passing every, and this order has not been preferred and appeal before the Honorable Supreme Court. This is it has, that order has been complied with.
What is 9 December 2015 in MAT 1598?
My lord, 1598. So this is my lord the 1598 is the initial order.
But it is a case where writ petitioner did not exercise option.
Yes.
But here you are submitting that the teacher died before issuance of the memo dated 13 June
Here also,
2016.
same, my lord. Here also, my lord, the deceased, my lord, the employee died 2005.
Yes,
Yes.
but that is not the case here.
Yes, my lord.
Come to the judgment of the order of the division bench dated 20 June 2016.
Yes, my lord. 28.
8 June 2016.
My lord.
By the honorable division bench.
My lord.
On the review, passed on review application.
My lord.
Then
Kindly-
first, second, third, fourth page, first paragraph. After first, second, third, fourth, fifth, sixth line. The writ petitioner before us did not exercise option, but not could not. Therefore, she was not entitled to the benefit of pension and gratuity.
My lord, she was reading.
He submitted that this point was inadvertently not raised by the learned advocate appearing for the state when the appeal was heard by a bench to which none of us was party.
My lord, she was reading, my lord.
Third page of the judge order of the division bench dated 20 June 2016, passed on review application.
The aforesaid question, my lord, this aforesaid question.
Yes,
was
I have
answered.
marked it by pencil. Read it. Where the teacher was alive, but he or she chose not to exercise option. Here, teacher died prior to issuance of memo dated 13 June 2016. So, if I accept your contention, then all persons who have died or who died prior to 13 June 2016 should be given opportunity of switching over from pension from CPF to GPF. Fact
No, no, my lord. This
fact
is, my lord,
situation was different.
No, my lord. This, my lord, the submission made by
Tell me when the teacher died.
2005. 2005 teacher.
So all death candidates should be granted opportunity of switching over.
Yes, my lord. That is
Yes.
this is the judgment.
But that is not the case.
My lord,
Which you are relying. So,
no, my lord, subject को. Page, my lord, paragraph 16. my lord.
देखिए ना CPF to GPF ये दाও.
Kindly see the order, my lord. The husband died, my lord. Here, my lord, the wife has come. Here, this Jharna Bhatta is the, my lord, the wife of the deceased employee. He filed a writ petition. He filed a writ petition.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner is the husband.
Petitioner
is the husband.
Yes, my lord.
Petitioner is the husband of a deceased teacher who died in 2005.
No. My lord, in this case, Jharna Bhatta's case 2005.
Here?
Here, my lord, 2014. Prior to my lord, notification.
10/6/2014 according to this.
10/6, not prior to notification.
Yes.
This notification was issued on
13
June
And
2014.
my husband, wife died 10th June.
Yes. কি বলছিলাম? Who died prior to issuance of notification dated 13 June 2014, whereby state government granted opportunity to exercise option for switching over from CPF to GPF in terms of the judgment of the special bench dated 16 July 2013, passed on intra-court appeal being APO number 94 of 2009, within bracket state of West Bengal and others versus Obijit Boiddo and others. Stop. Husband has come with the present petition seeking direction for getting the benefit of pension on switching over from CPF to GPF. Stop. In support of such contention, reliance is placed on the judgment dated 28 June 2016, passed by the Honorable Division Bench on review application being RVW number 68 of 2016, within bracket the state of West Bengal and others versus Srimati Jharna Bhattacharya and others. So, on perusal of the judgment dated 28 June 2016, it appears the writ petitioner did not exercise option.
No.
Within time, in terms of government notification dated 13 June 2014. But in the present case, teacher died prior to 13 June 2014, being the date of notification, or teacher died prior to issuance of notification, on 13 June 2014, giving opportunity to the retired teachers to exercise option for switching over from EPF to GPF. Next one. In view of aforesaid, court finds that the issue needs to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 1 week after ensuing puja vacation. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next one. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next. Mr. Thakur.
Item number 15.
So the school authorities has been served. 2011, my lord, the petitioner, my lord, joined as assistant teacher. Housing rent allowance of the petitioner, my lord, continued up to February 2018. From February 2018 to June 2022, my lord, there has been a gap. The matter, my lord, unofficially she was informed that, my lord, her husband was working in a private organization drawing HRA. And that's why, my lord, she was not entitled to it. And, my lord, this issue, my lord, came up before this honorable court. And, my lord, it was settled that, my lord, the HRA, my lord, in case of spouses who are working, my lord, in non-governmental organization, my lord, the HRA of the, my lord, the other spouse, my lord, cannot be, my lord, restricted. And, my lord, it was directed, your lordship, my lord, kindly takes up, my lord, my lord, annex the order itself. Task at, my lord, page number 25.
No, I have to release it.
Yes.
But if you
Take back affidavit service, you take back, you release করে দেবে HRA matter.
HRA. Lordship,
They order to pass. 16 March 2021 that HRA released.
Yes.
Released.
Item number 16. 16, my lord, I am appearing on behalf of the petitioner. My lord, I am submitting the affidavit of service.
Yes. Yes.
My lord, the petitioner was appointed as an assistant teacher in mathematics in Parsola Banimitan Vidyanikodan.
You are seeking pension.
Yes, my lord.
So when you retired?
My lord, retired 31st March 2025.
Why you are not getting pension?
I don't know, my lord.
Where the pension papers are lying?
My lord, pension paper is lying most probably before the DI.
Are you aware of whether the school authority has forwarded the pension papers to the DI or not?
No, my
You are appealing for the school.
Yes.
Yes. What is your instruction?
It has already been forwarded. Lord, it has been written with certain direction by the DI concern. We have asked, my lord, the petitioner. My lord, he was the headmaster. During his service period, my lord, he did with regard to, my lord, submission of pension paper. But these defects would be removed. Hmm? Yeah. Hmm.
Of course, you. So these objections are to be clarified.
My lord, I did not issue any copy to my clients.
Give a copy.
My lord, kindly see the annex,
Obtain-
the last.
No, there are certain objections. These are to be clarified.
Yes, my lord, just he is handed over to me.
Well, already we have informed the
Proper is not
headmaster
found.
concerned
Complete statutory
by writing
certificate.
letter. And my lord, he has contacted. My lord, we have requested him to have my lord to give copy.
So why you are saying you don't know, you are not getting any instruction? School is saying that it was informed to the headmaster, and headmaster is taking steps for
I have served the copy upon the headmaster.
for curing this defect.
My lord, I have served the copy of the writ petition upon the headmaster managing committee.
Teacher in charge.
I
Why
also served.
you do not have any instruction. This is a memo dated 28 August 2025. It was forwarded to the headmaster by the school authority. Headmaster contacted the school authority for curing defects, and you are saying that you do not know anything.
No, my lord, after filing.
Then headmaster,
My lord, after.
then your client is not giving you appropriate instructions.
My lord, after filing this writ petition, they have.
Your
issued-
client is not giving you the proper instruction.
To the school authority.
Yes.
Why, my lord, they have.
Not to the school authority, to you.
They have, my client has received any copy.
These objections are to be clarified.
Yes, I will clarify.
You
If they-
cannot clarify. Headmaster has to attend the school for curing these defects.
My lord, time and again he has attended the school. My lord, kindly see. My lord, just
Tell me after 28 August 2025 when he attended the school.
28 August 2025.
After.
My lord, 28 August 25, my
Yes.
client did not receive any copy from the.
Has received his copy, school has forwarded it to the headmaster, to the petitioner.
Toibal Vishwas. Copy. 28 August 25.
This is the instruction of the DI, my lord, that he has been stated to the school to clarify the defects.
Yes,
So-
this is with me.
so-
Please wait. This is not a place for having consultation with your client.
My lord, my lord, the.
I am very sorry to say, this is not a place for holding conference.
Yes, my lord.
Obtain instruction and come back.
My lord, actually the school
Affidavit,
authority.
please
my
don't
lord,
waste court's time.
My lord, kindly see my documents.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Grievance of the petitioner is in spite of superannuation on 31st March 2025 from the post of headmaster till date. Petitioner is not getting pension and other till date petitioner has not received pension and other royalties. Next paragraph. Learned advocates representing the school authority and state respondents has submitted that there were certain objections raised by the District Inspector of Schools AC Africa while processing pension case of the petitioner, and Vide memo dated 28 August 2025. Pension case was returned to the District Inspector of Schools, returned to the school authority for taking necessary steps. Stop. Copy of the memo dated 28 August 2025 is made over to the learned advocate representing the petitioner learned advocate representing the petitioner during course of hearing. Stop. Copy of the memo dated 28 August 2025 is also taken on record. Next paragraph. Having seen that there are certain requirement which are to be carried out, it is now on perusal of memo dated 28 August 2025, court finds school authority is required to take steps. Now, court finds teacher in charge of the school being respondent number 7 is required to take steps to cure defects in the pension file of the petitioner or in the pension papers of the petitioner with the assistance of the petitioner. The petitioner shall be at leave to attend this the school by 10 days from date for taking necessary steps in order to prepare pension papers ready before forwarding those papers to the District Inspector of Schools, AC Bankura being respondent number 4. Next paragraph. Hearing of this matter stands adjourned for fortnight. Next paragraph. On the next date, respondent number 7 is directed to file a report. Next paragraph. List the matter under the same heading for further consideration on 25th September 2025.
Petitioner directed to supply us all necessary papers because all
next matter. Take steps for curing defects. I am telling the school authority.
Right.
Yes.
Item number 17.
I'm appearing for the petition of court.
I'm for the respondent number 19 and 20.
The prayer in this writ petition is connection to the due PF amount along with the interest, my lord. The petitioner before your lordship is a lady of aged about 75 years. She joined in service in the year 19.
You are for
14 and 16.
Who are they?
School secretary, headmaster.
And you are for?
My lord, I am for 17, my lord. I am the erstwhile member of the staff council and present we are being present. I also, my lord, against this headmaster by
Which is
the
And you are for?
So, my lord, preferred writ petition, my lord.
Against this headmaster?
Yes, I'm teacher representative as well as non-teaching staff representative.
State. Yes.
My lord, I joined in service in the year 1978 under Nachipur Adivasi High School and Hattan, and I retired from the school in the year 31st March 2008. After that, in the year 2012, the PF amount that accrued in my favor was ₹7,93,499. However, a part payment was made.
When?
It was made on 18 September 2012.
So after part payment, why you are coming after 13 years?
Lordship, because there was a due amount of 87,498 rupees. That amount was not paid, and when we collected the information regarding that,
so now you are seeking 87,000 and not.
No, man, I'm paying for that 1,15,000, even though I have an submission that this calculation which has been made is erroneous.
No, but why you are coming since you retired on 31st March 2010? Payment was made towards Provident Fund dues on 18 September 2012.
Right.
So why you have filed the writ petition on 7th August 2025?
My lord,
After 13 years.
the reason behind that, I have stated so in my repetition also, that when I inquired regarding my due payment that was made, supposed to be paid to me, my lord, there was a serious allegation against the headmaster because the bribe of 15,000 was asked from me. That I complained this regarding this matter to the staff council also. That a bribe of rupees 15,000 was asked and I have paid that amount. I admittedly say because I have given that document. I made a complaint before the police authorities also and other authorities also.
But for that, why 13 years delay? You could have come before this court in 2012 itself.
My lord, at that particular time, I have stated so that due to various ailments, I couldn't. Presently I'm aged 75 years.
After 13 years, you will come for non-payment of Provident Fund dues.
My lord, I was moving here and there and asking for this.
That is
amount
not an
because
explanation for explanation of delay.
I understand. But in the delay part, I have only stated that since I was alone in my family and had to leave with
Yes,
this.
why part payment was made? Who is for the
But
school
the
authority? Who is appearing for the school authority?
I am.
Why entire amount was not
I'm
paid?
coming. Petitioner superannuated on 30th September 2010. Headmaster joined as a headmaster on 1st August 2014. And thereafter in the
Petitioner was also headmaster.
petitioner
Administrator. Assistant teacher.
While while Excel sheet was on preparation, an erroneous entry was found. And it is found that to the tune of rupees 1,15,000 has been stated, but she is not at all entitled to get. And there is a resolution. Actually, he has been paid an excess amount of rupees 161. That is in the year.
How much amount was paid towards Provident Fund? Issue is Provident Fund.
7,06,084 was the due.
7,06,084
Was due, and 7,06,201 is paid.
7,06,000
201 is paid.
7,06,201
is paid. And kindly see that this is the resolution.
706084 was due.
Due.
Now paid due amount.
Yes.
Provident Fund paid was 706,201.
And that is also
201.
Yes, and that is also paid on 17/8/2012. But I joined as a headmaster in the school.
So that is according to his excess payment.
There is an excess payment of 161.
161.
161. And
Is it your case that beyond 706201 nothing is payable?
Yes.
Then on what basis petitioner is claiming 706084?
That is there 6 lakh something and an interest for 6 months was there added. And see,
so, but there is no much difference. It is 7,06,084 and paid is 7,06,201. It is higher than the amount due.
Yes, that is the issue.
And according to you, what was the amount payable?
May I humbly pay one document?
According to you, what is the amount payable?
Amount that is left over was 1,15,696.
1 lakh?
Without 1,15,696. That is without interest, my lord. 115696 is due. Yes, sir.
But the amount is disputed.
May I show one document that is appearing?
What is the instruction of the state?
No, my lord, I have taken instruction, my lord, so far as the she claimed for, my lord, that the payment should be made. He has got only part payment. We wrote letter to the school authority, clarify this. The school authority, my lord, said, my lord, 117 rupees is excess payment has been made to him. She is entitled only, my lord, the 6 months due.
And
Interest.
The authority has already informed to the
issue.
DI.
Affidavit of service. At this stage, it's not required. File your affidavits. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner retired on superannuation on 31st March 2010 from the post of assistant teacher. Stop. After superannuation, petitioner was paid retirement dues, including Provident Fund. Stop. Learned advocate representing the petitioner prays for direction for release of unpaid amount towards Provident Fund. Stop. According to the petitioner, amount which was payable towards Provident Fund was not fully paid.
This is according to school also.
Stop. Next paragraph. However, the learned advocate representing the school authority submits on superannuation of the petitioner. She was paid. She was paid rupees 706201. 706201. And there was an excess payment to the extent of rupees 117. To the extent of rupees 117. 117. Stop. Stop. Learned advocate representing the school authority disputes the contention of the petitioner that full and final amount was not paid towards Provident Fund at the material point of time. Stop. Next paragraph. Furthermore, there is no plausible explanation of delay in approaching this court, seeking direction for release of unpaid Provident Fund dues. As the petitioner retired on 31st March 2010 and present writ petition was filed on 7th August 2025. Next paragraph. Issue involved in this writ petition needs to be decided on exchange of affidavits. Next paragraph. Let affidavit in opposition to this writ petition be filed by 2 weeks after ensuing notification. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench having determination after the time fixed herein above for exchanging affidavits. All parties are present?
Yes.
Stop. Next paragraph. Point of delay is kept open. Please call the list.
Item number 18.
My lord,
Yes.
I am for the petitioner. The matter is about a compassionate appointment. Petitioner mother was a Group D approved staff in Lajpat Balika Vidyalaya. His normal retirement date was 30th September 2022.
Yes.
But normal date of retirement on superannuation.
Whose superannuation?
Petitioner's mother was a Group D staff of Lajpat Balika Vidyalaya under the jurisdiction of Kolkata DI.
Yes. When mother died?
His mother died on 22nd June 2018. The petitioner applied for the compensation appointment within 3 months, 12th September 2018.
Yes. When?
12th September 2018. My lord, kindly see the page.
Now, whether the application of the petitioner has been decided?
No.
It has been decided.
Where is the decision?
But, it was communicated, but he has not. Communication from the school to the DI after 7 years.
After?
25.
After 7 years? Why? After filing this writ petition?
No, before filing. Kindly see page 34. It is a delay caused by the concerned school administrator. They communicated that application to the DI, and DI has just given the instruction to me. That
page 34.
30. Can you see the date of communication 7/4/2020 with all documents? The first page.
My lord, kindly see the page.
Just a minute. So this was forwarded by the school authority on 7th April 2025. Then where is the decision?
Decision. May I have the instruction to me?
Oh, no decision has been communicated to the
Has been communicated to the HM, and there was
why it is not?
direction.
Why it is not communicated to the petitioners? You are appearing for whom?
I am for the DI.
Why it is not been communicated to the petitioner?
It is communicated to the HM, and she is requested to communicate it to the petitioner itself, to the school.
My lord, I had applied within 3 months. Kindly see page 21. My first.
Where is the decision? DI has said that it is not within time. On what basis? When the application was made within time?
The school. If your lordship kindly takes the rule itself, interpretation has been given in that fashion. Kindly see page 58. So there are the whatever. Page 58 says, in that tune, BI has communicated.
page 58 of the petition itself, the rule has been annexed. That is a.
The headmaster's manual to allow. Is it the case that the petitioner did not apply within time?
No, it is not the case. It is
Then why
the-
DI has said so?
That is only from borrowing from that. Can you see this? You also can interpret with that. He has made an application within the time to the school. School did not forward. That is
Why for that why petitioner will be
that is
penalized?
there. Can you see the interpretation of the student? My lord will get it from 58 of the petition itself.
Yes, which rule you are relying on? 2009?
2009
Yes, 2009 rules.
column 5, schedule 5 of rule.
Yes, schedule 5.
First paragraph. If the deceased teacher after the three columns spouse, son, daughter, thereafter, if the deceased teacher and non-teaching staff of the family who is petition is required to educational qualification sentence 18 to 45 years, within 2 years from the date of death, make an application in writing to the DA. That is why he is interpreting in that.
But normally this is submitted before the school authority.
But rule says it is to be to the DA. That is why he is interpreting.
How you have applied, show me.
I leave it to Lord Chimal, only second.
Yes, how you have applied, show me.
Kindly see page number, sir. My lord, kindly see page number 21.
कुछ नहीं है.
Consider it on merit.
My lord, one thing I would like to draw your attention, my lord. Actually, what happened? The PPO was issued 6 year delayed. After 6 year PPO was issued, that is why the school authority was not sending the proposal. My lord, kindly see the page number 23. Only death gratuity was issued in 2024, May 2024.
Issue. এখানে তো অসুবিধা হবে জিজ্ঞেস কে আসেনি একদম আমি তো শুনি affidavit of service file your affidavit. Yes, affidavit of service filed on behalf of the petitioner.
My lord, all other
Please take your seat. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. By presenting this writ petition, comma, inter alia, comma, petitioner has claimed appointment on compassionate ground due to death of his mother in harness on 22nd June 2018, who was Group D staff of Lajpat Balika Vidyalaya within bracket HS, close bracket, Kolkata. His learned advocate for the petitioner submits after death of petitioner's mother on 22nd June 2018, application for appointment on compassionate ground was filed or was made before the ওই উপরে যে স্কুল অথরিটিকে বললেন না সেট স্কুল অথরিটি করে দেবে তো হিয়ারিং আপনার রিফার টু এ সেট স্কুল অথরিটি কোট আনকোট সেট স্কুল অথরিটি কোট আনকোট আর উইদিন ব্র্যাকেট হিয়ারিং আপনার রিফার টু সেট তো কি বলছিলাম সেন্টেন্সটা said school before the said school authority on 12 September 2018 and the then headmistress of the said school issued acknowledgement on the same date. Stop. Grievance of the petitioner is though application seeking appointment on compassionate ground was made far back on 12 September 2018, but till date, decision has not been taken by the concerned respondent authorities on the claim of the petitioner seeking appointment on compassionate ground. Next paragraph. Learned advocate representing the state respondents has placed before this court one memo dated 1st July 2025 issued by the District Inspector of Schools AC Kolkata and same is taken on record. Next paragraph. On perusal of said memo dated 1st July 2025, it appears prayer of the petitioner for appointment on compassionate ground was rejected on the premise that petitioner could not file application within time as per relevant rules. Stop. As per relevant rules, after the death of his mother. Stop. It is submitted in reference to rules relating to compassionate appointment that application for compassionate appointment is required to be submitted before the concerned district inspector of schools within bracket before the concerned district inspector of schools within 2 years from the date of death of the employee, which has not been done in the present case. Next paragraph. On consultation of the facts, it appears that petitioner made application for appointment on compassionate ground on 12 September 2018 before the said school authority after death of his mother on 22nd June 2018. Which is before completion of 2 years from the date of death of employee. Stop. It is not a case that petitioner did not make application for appointment on compassionate ground within period of 2 years. Rather, application was made within the specified time of 2 years. But instead of district inspector of schools, instead of submitting application before the district inspector of schools, concerned district inspector of schools AC, it was submitted before the school authority where mother of the petitioner was working. Stop. Next slide. Said school, being a government aided recognized institution, was required to forward application of the petitioner dated 12 September 2018 to the concerned district inspector of schools AC Kolkata, being respondent number 8, within a reasonable time, but same was not done. So, it was the duty of the said school authority to forward the application of the petitioner dated 12 September 2018 to the respondent number 8 immediately after receiving the same from the petitioner. So, therefore, delay caused. Therefore, delay occurred due to laches on the part of said school authority, not by the petitioner, for which petitioner ought not to for which petitioner ought not suffer. So, next slide. With a memo dated 1st July 2025, on the sole ground that application for appointment on compassionate ground was not submitted within the specified time of 2 years, same was rejected. But it was not taken into consideration by the respondent number 8 that there was no lapses on the part of the petitioner in preferring application within stipulated time seeking appointment on compassionate. School authority made delay in forwarding application for appointment on compassionate ground to the respondent, said school authority. In forwarding application for appointment on compassionate ground, কি বললাম সেন্টেন্সটা, স্কুল অথরিটি মেড ডিলে, তাই তো? To the respondent number 8. Stop. Next. Hence, memo dated 1st July 2025 issued by respondent number 8 is set aside. Stop. Respondent number 8 is directed to take decision on application of the petitioner seeking appointment on compassionate ground, which is at page 21 of the writ petition, by 4 weeks from the date of communication of this order, and the decision to be communicated to the petitioner by fortnight thereafter. Next slide. Writ petition stands disposed of urgent.
Item number 19.
The status found, my lord.
Yes.
1970. Thereafter, my lord, finally school, my lord.
You are for the state, my lord. Who is for the school authority?
I have the copy.
When?
Long ago.
8 August 2025.
So, your lordship can see.
Find it out when it was served.
I can use the reference. Gary got the reference. He got all the particulars.
Show me when school authority received it. এই এসিটা কমা টেম্পারেচারটা গরম করছে তো এবার respondent numbers 6 and 7 received.
They received a lot of 88. Your lordship can see.
গালা হবে তারপর
All right. All 46. 58 to 58 to 25 and 88 to
Without yes.
petitioner attended school from September to
Could not attend.
could not attend because due to illness. And he
Correct.
made it there to this to prepare the service. And I want to prepare the service.
When from when petitioner could not attend?
On 4th February 2085.
4th February
2085. He was very much irregular.
85.
Yes.
Till which date he could not attend?
That is on 4th February.
85 till?
Till
For which period he could not attend?
But till the date of superannuation.
When superannuation, when petitioner reached age of 60?
They say the age of 60.
When petitioner was due to retire?
Your lordship can answer. And I came before this court.
When due to retire?
Due to retire. How that work?
অর্ডার শিট তোলা যায়
2018.
Where you have stated? Yes. If it is 2018, there is a deemed abandonment of service.
And court passed an order to the effect, directed the commissioner to
What consideration? There's a leave rules that if you remain absent for a period of 5 years, for a period of 5 years, there will be a deemed termination.
The school authority could have send the letter to the board because board is
Why school authority? What steps you did take? From 85 to 2018, you did not attend the school?
But it came before this court and court passed their order. He said that they pension
Under what provision, Mr. Borua?
10 years service to complete. I have completed more than 10 years service. I have 14 years service. So as I have
You did not attend the school. There was a deemed termination under the leave rules.
But 10 years service, I required not 10 years service.
Where is the order of this court?
Yes, Your Worship, can you come to page
26.
Started from page 26 and relevant question is heard to page 29.
So you are challenging 19 July 2019 order.
Yes.
That is in 2025 after 6 years.
But because now he is bedridden.
Whether petitioner is bedridden from 1985.
He is very much irregular because there is several ailments. And Your Worship can see the order.
You have not worked. Where is the question of payment of pension?
I 10 years past 10 years service or 14 years service.
I could understand that petitioner applied for voluntary retirement.
Yes, I applied before the authority, school authority. School authority did not say.
School authority is not the appropriate authority for that. What steps you did take for obtaining approval from board?
Yes, board didn't take any step. You can see the order of the passed by the direct Commission of School Education. Once case 30 starts from case 30. The relevant portion is the case 31 and 32. 33.
But again, I guess not. No.
What is the provision of half pension? Is there any indication in the DCRB scheme?
But on ending year, kindly see they stated the Commissioner of School Education itself stated on attaining the age of superannuation, a voluntary leader after completion of
Yes,
the treatment of qualifications.
Affidavit service filed on behalf of the petition is taken on record. Next one. In the writ petition, memo dated 19 July 2019, issued by the Deputy Director of School Education. No, issued by the Commissioner. In the writ petition. No, in the writ petition, in the writ petition, decision of the Commissioner of School Education West Bengal, which is annexed P3 to this writ petition, is questioned. Stop. Decision was taken by the Commissioner of School Education on 2019, and the present writ petition is filed on 8 August 2025, after 6 years. Stop. Next paragraph. Issue needs to be decided on exchange of affidavits. Next paragraph. Let affidavit in opposition to this writ petition be filed by the let affidavit in opposition to this writ petition be filed by 2 weeks after ensuing puja-vacation. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks. Petitioner shall be at liberty to mention the matter before the bench having determination for hearing after the time fixed herein above for exchanging affidavits. Next paragraph. Blind advocate for the petitioner is directed to communicate this order to the non-appearing respondents by 7 days from date and file affidavit. I said resignation.
Item number 20.
Petitioner applied for the transfer on a medical ground. There are several occasions he has applied for, but on 18th February 2024, 2022, he applied
for transfer on medical
ground.
On the portal.
On the portal.
Where is the status of the application?
Is
page 23.
22.
20. Is 22. For 18 February 2022.
Where is your what is the date of your last application?
This is the last
7 January 2022.
18th February 2022.
It was on medical ground.
It is on a medical ground.
But it was not forwarded by the school authority.
Subsequently, it was forwarded. Subsequently, it was forwarded by to DI and forwarded to the School Service Commission.
But there is no indication or it is not reflected from this
due to
from the document at page 22.
Due to suspension of the portal, my lord, I would not receive the forwarding letter about forwarding letter.
You are for the DI.
I am for the DI, but
whether it was forwarded to the commission.
I have the latest instruction. It has been, but from the track record, I have not found one. If you also kindly, there are a report of the BMOH page 18. Not satisfactory. It is there.
No, but the DI is required to obtain a report from CMI.
CMI
report obtained, madam.
Where is the report?
Page 19. But it is not in consonance with the sending by the DI itself. I have not found anything. Where from this document my brother has got.
It has been allowed.
Hello.
In this regard, her prayer for transfer on medical ground near to her house may be considered for better outcome.
My lord, from the
And it is stated, it is being understood that the patient needs long-term follow-up.
yes, my lord. But my lord, in comparison with
That's why DI forwarded it.
Yeah, on very that day it was forwarded that is the instruction to me. But from the petition,
my lord, but
Long-term treatment is required and a better outcome can be achieved if petitioner stays near to the place of work.
my lord, seems my lord, this is my lord contrary to the page 22, my lord, because from the Utsosri portal status, nothing has been found. The district inspector of school has forwarded the document to the school service commission. So my lord,
So let me direct the DI to forward it if it is not forwarded.
forwarded.
If
That
it is
instruction I have. That is
and my lord, then my lord, kindly direct the school service commission. If it is received, my lord, then kindly direct it for consideration.
received.
My lord, whether my lord, district inspector of school has forwarded or not, my lord, that is not apparent from the portal status, my lord.
column 4. এটা কপি নিবি
নিয়ে করবো কি
তুই দেখাবি কি পেয়েছিস ডিআই ইনস্ট্রাকশন বাবা এর বাইরে আমি কি বলবো বল না কিন্তু যেটা
না না অবশ্যই
ইনস্ট্রাকশনটা ঠিকঠাক না
just.
দেখলাম না একটা কন্ট্রারি ওর মধ্যে উল্টো পাল্টা লেখা দেখি
DI is saying that on 25th March,
March.
it was sent.
Sent.
So let it be considered by the commission based on medical report, which is at page 19.
Page
Court is directing the commission to take decision. Why? On the basis of this medical report.
The school service commission told the petitioner that she has no guidance in the school. But I find at school, the indicated in this application, she finds the page 27. Yet received by the school service commission.
Then you have to make an application in the prescribed form pro forma afresh. Court will not direct in that. If you find that vacancies which have been indicated or disclosed in your transfer application dated 18th February 2022, those vacancies are not available today, then there is no scope of transferring the petitioner.
না এটা আমার
Then you have to make an fresh application in prescribed pro forma in offline mode.
Probably reject করেছে
You have to take a specific stand. Yes.
application prior to date of medical report 2024 page 20
Which application?
page 27
No, that is court is not considering.
Not all.
Affidavit of service filed
Yes.
on behalf of the
সেটার
petitioner is
উপরে
taken on
রিজেক্ট
board.
করেছে এরকম নয় তো
Next paragraph. Petitioner
Gets in
made
a
an
policy
application for transfer on medical ground on portal on 18th February 2022. Stop. It is submitted by the learned advocates representing the petitioner and state respondents. That petitioner was examined by the medical expert and a report was furnished on 24th March 2022 by the Chief Medical Officer of Health, Diamond Harbour Health District. Stop. It is also submitted that transfer application of the petitioner in consideration of medical report dated 24th March 2022 was forwarded to the West Bengal Central School Service Commission for taking decision. However, till date, Commission has not taken any decision on transfer application of the petition. Stop. Next paragraph, petitioner prays for direction upon the Commission to decide her transfer application. Next paragraph, a report or a communication dated 20 August 2025 of the District Inspector of Schools AC South 24 Parganas, being respondent number 5 is placed before this court and same is taken on record. From the said report dated from the said communication dated 20 August 2025, it appears that respondent number 5 forwarded the transfer application to the Commission on 25th March 2022. Stop. Next paragraph. Reliance is also placed on medical report dated 24th March 2022, wherein it was opined that the petitioner needs long-term follow-up, and if petitioner and transfer of petitioner nearby to her place of residence could ensure better result. Next paragraph. Taking note of the medical report dated 24th March 2022, Chairman of the Commission, being respondent number 4, is directed to decide the transfer application of the petitioner by 4 weeks from the date of communication of this order. Decision to be the decision to be taken by respondent number 4 shall be communicated to the petitioner by 10 days thereafter. Next paragraph. It is made clear that suspension of portal shall not be a ground to reject transfer application of the petition. Writ petition stands disposed of. প্রথমে যে কমিশনটা করেছিল না আপনার হিয়ারিং একটা রেফার টু শর্ট কমিশন করেছে
ইনস্ট্রাকশনটা রাখবে
একটা কপি
Item number 21.
Yes. What increment? Increment 3% additional increment. Have you made any representation?
Page number 30. 30.
এই 3% additional increment এর usual order দাও তো। Page number 30. 13. 13.
No, my lord.
30.
30.
Still petitioner is working or has retired? When retired?
Sir, my lord.
31st October 2022.
For retirement already made there.
3%
What you are doing prior to retirement? Why you did not approach the authority prior to retirement? Show me any representation. Page 22. Show me that prior to 31st of October 2022, you prayed for sanction of additional increment. না এটা না সুবীর ঘোষ দেখো সুবীর কালীসাধন ভট্টাচার্য সুবীর ঘোষ জাজমেন্ট But this is not a representation. It was forwarded by the president of the school.
President only covered it. Thereafter, my lord, that can be taken as
But prayer for 2 additional increment is not the benefit. Benefit is 3% additional increment.
Yes, my lord. Paragraph 11 as stated. 20 years service completed as a result.
That is different thing. Are you seeking 3% additional increment for the post of headmaster, for holding the post of headmaster, or for working in the post of headmaster on superannuation on upgradation of the school?
Yes.
Where is stated? It's not a 2 additional increment.
2 additional means, my lord,
1% additional increment.
Additional increment was granted firstly, and thereafter, my lord, the return. That is why you overturn the amount in return. Page annex 3, page 19. Means the purpose of granting pension.
Well, you obtain an instruction and submit it.
Yes, madam. That is madam.
File your affidavit service. Then nothing can be, you should have submitted this at the threshold. Record an order. Matter is taken up for consideration when learned advocate representing the petitioner has prayed for accommodation. Stop. State respondents are represented by learned advocate. Next paragraph. List the matter for under the same heading for further consideration on 28 October 2025. Next. 28 October. Next. Call the matters from combined list. Why you are not saying that you are not in a position to file affidavit of service? Wasting court's time unnecessarily? Yes, yes, call the matters from the combined list.
Item number 186, monthly list of appellate site.
ইয়ে করে দাও তো কি বললাম সে লিস্টে দেখো ওয়েট under the heading motion. Yes. Yes, yes. Yes. Similar matter. What is the issue? No, it's not similar matters. You have to place it.
But requirements of paper, Lord.
Yes.
The paper has been required to the school, not send the DI. Some paper has been requirement by the Lordship District Inspector.
Who requires paper?
District Inspector of school.
Then
To the
submit a
school.
report.
And then Lordship.
Submit a report. Matter is taken up for consideration in presence of the learned advocates representing the petitioner, state respondents, and the school authority. Next paragraph. Petitioner prays for incremental benefits and arrear salary.
10 years incremental.
Due to upgradation of pay in terms of ROPA 2019. Petitioner prays for release of incremental benefits and arrear salary due to refixation of pay in terms of ROPA 2019. Next paragraph. Mr. Boisho, learned additional government tutor representing the state respondents, prays for accommodation. Now, representing the state respondents submits that District Inspector of Schools.
Lordship, I am appearing on behalf of the school of
District Inspector of Schools AC Howrah requires certain documents
from the school,
from the authority of Goaberia High School, Howrah, for taking steps based on claim of the petition. So, next paragraph. District Inspector of Schools AC Howrah, being respondent 4, shall be at leave to obtain necessary documents from the aforesaid school authority by fortnight from date, and necessary steps shall be taken in accordance with law for releasing benefits to the petitioner as prayed for, if petitioner is found eligible. Stop. Next, after aforesaid exercise, District Inspector of Schools AC Howrah is directed to file a report in the form of affidavit by 4 weeks thereafter. Fortnight, 4 weeks. Next paragraph. List the matter under the same heading for further consideration in the monthly combined list of November 2020. Next matter.
Subject to correction.
Next matter. Please call the next matter.
86, 87.
Item number 187.
Yes. 10-year service benefit.
87.
Same school, same issue. Who is for the state? Who is for the state? You are for the state. Who is for the state?
Lordship, I am appearing on behalf of the respondent number 5 and 6.
You are for the school authority, I know, and headmaster is the root cause. That is also known to me.
Lordship, subject to
So
correction.
therefore, please don't open your mouth too wide. Wait.
Lordship, subject to correction, there is a no negligence on the part of the headmaster, Lordship. Several times.
Who is appearing for the state? How many matters you have? This is 186 and 187.
191.
186, then 191, 192. What you are claiming? 10 years benefit. Salary?
January and February.
2019 Ropa.
Lordship, petitioner get
Acha,
the
issue
salary
to.
according to the.
Where is your
Ropa
affidavit of
9,
service?
but not getting the Ropa 19. But petitioner get the benefit of Ropa 2009. Because of that, petitioner raised the letters
Affidavit of
before
service
the
filed on
administrative
behalf of the
authority.
petitioner. Please take your seat. Affidavit of service filed on behalf of the petitioner. Affidavit of service filed on behalf of the petitioner is taken on. Next paragraph. কি বললাম বলো তো আগের অর্ডারটা? একই স্কুল একই জিনিস। হ্যাঁ, petitioner prays for incremental benefits না করে petitioner prays for sanction of 10 years service benefits and arrear salary তারপর due to দেখো
191
তারপর না state respondents are not present
গোবিন্দ না কে যেন
in spite of
90
service of notice.
গোবিন্দ কুমার নস্কর
However, school authority is represented. তারপর কি বললাম? আগে তো হয়েই গেল না স্যার স্টপ ডিস্ট্রিক্ট স্কুলস এসি হাওড়া being respondent number Mr. Boisho, you appear in this matter. Same issue, same school.
What happened to that spring?
Yes. No, but in spite of you are appearing for the school in this matter. Very good. কি বলছিলাম দেখা চললে তুমি ঠিক Mr. Samant, my lord. Full name?
Jayanta Samant.
Jayanta Samant, right. 186. শুধু ডিফারেন্স হচ্ছে 10 years benefit salary and arrear salary on refixation of pay যেটা বললাম as per Rupa 29. Mr. Samanto, there is a similar claims are made by the teachers of other teachers also. In the previous matter, Mr. Boisho was appearing for the state in connection with another teacher, where prayer is made either for sanction of 10 years benefit or 20 years benefits or incremental benefits along with arrear salary due to division of pay as per Rupa 19. It is found that the headmaster is the cause for not releasing or extending these benefits. Now, in the previous matter, Mr. Boisho has submitted that there are certain documents which are required so far DI is concerned. Leave was granted to the DI to obtain those documents from the school authority and thereafter take steps for releasing those benefits in accordance with law if petitioner is found eligible. So a time is fixed for all the fortnight for obtaining documents from school and 4 weeks thereafter for releasing benefits if petitioner is found to be eligible for. And a report is directed to be filed on the next date. Matter was posted in the monthly combined list of November 20. Same order I am passing in your. Yes. But the state is 191 where the state is present. 191 you are present, you are for the state. 192
191
yeah, you are for the state.
189
187
191 call for 187 and 88 I am there. 187 and 188.
89 I have applied for the state. It's not the identical matter.
192 state is not present. 192 you are for the state. Very good. 191, 192 taken out.
188.
Item number 191.
What is your instruction, Mr.
My instruction is that there is some objection, but we did a school authority.
What is the prayer? 191. Arrear salary. 10 years increment, 10 years service benefits, not increment. Benefits and arrear salary as per ROPA 2019.
My last instruction is the said area bill is now under process for submission before the treasury.
So that's why it has rightly pointed out by Mr. Boisho
I heard
in previous matter that DI requires certain document. Court is granting permission, leave to the, not permission, leave to the DI to obtain those documents by fortnight from date from the school authority. And after obtaining those documents, if it is found that petitioner is eligible to get these benefits, appropriate steps to be taken. And a report is to be filed on the next day. 10 years benefit করে দেবে and ওই arrear salary as per ROPA 29. Same, otherwise সব same. Advocate এর নাম change হবে state. Same order, monthly list of November. You are appealing for the school? Yes. Give your appearance. Then 192.
192.
Item number 192.
Yes, you are for the state. What is the prayer? 10 years service benefits, arrear salary as per ROPA 19.
ROPA 19.
Same order. I have not called for report. It is for your consumption. I have called for a report on the next date after completing the exercise. Same order. Now call item number 187. 88. 87 হয়ে গেছে? 188.
Item number 188.
Become infractual. SLST 2016.
Local arrangement
Transfer. Place your case. Page number 39.
Yes, that is the status.
Local arrangement made. Teacher found.
As per this status,
But not by the district inspector.
Then
By the private regiment.
by the private.
They have a private regiment. The DI has not found any.
on the school authority. I can see that.
Page 39.
Yes.
কি আছে?
No, no, there is no local arrangement. Only stating page 39 that there is a teacher having commensurating qualification in a neighboring school. But whether a school teacher is willing or not, that is not there.
And school authority have already arranged substitute teacher for that subject from other school.
Then the next upper column. Third column, then just above this endorsement, as per 3rd January 2022, head of the institution will not reject application, inform about it with name of nearby schools having same subject teacher for making local arrangement in your school. Head of the institution will forward application after communication of such arrangement. Yes. What is your instruction?
Copy my lord. User instruction has not received the transfer application.
But my school authority, my lord, self-made endeavor to find out a local arrangement, my lord, and forwarded the application to the DI. DI again, my lord, returned the application relying the 3rd January notification. My lord, it is the duty of the district.
3rd January notification.
Yes, it is the duty of the, as per 3rd January, it is the duty cast of the
DI.
inspector of school. My lord, so my lord, district inspector of school has to find
Then
out the
let me
alternate.
direct the DI to take steps, and if the school of the present petitioner, or if the present school of the petitioner has found a teacher, school authority shall be at leave to forward the name of that teacher to the DI for taking necessary steps in terms of the notification. Issue. But where is the status? It is not the status.
Yes, my lord, I have submitted the status, my lord. Better.
Application is dated 25th May 2022.
Yes.
Oh, DI has forwarded to again to the HOI. That is the
Return back.
Above.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph, petitioner made an application for transfer on on portal on 25th May 2022. However, petitioner was found to be single teacher in the subject in the school. Stop. Transfer application of the petitioner was forwarded by the school authority of the petitioner on 25th May 2022. But concerned district inspector of schools within bracket AC on 29th May 2022 sent the transfer application back to the school authority. Stop. It is submitted by the learned advocate representing the petitioner that in terms of government notification dated 3rd January 2022, concerned district inspector of schools within bracket AC is required to take steps for providing local arrangement in the school of the petitioner in order to facilitate transfer, in order to facilitate petitioner's transfer. Stop. It is also submitted that school authority of the petitioner has found a teacher of neighboring school who can be deputed in place of the petitioner after petitioner's transfer. Next paragraph. Respondent authorities are represented by learned advocates who have jointly submitted that in terms of government notification dated 3rd January 2022, it is the duty of the concerned district inspector of schools AC to find out a teacher of neighboring school who can be deputed in place of petitioner after petitioner's transfer. Stop. Next paragraph. Having considered the respective submissions made on behalf of the parties, District Inspector of Schools AC Howrah, being respondent number 7, is directed to make an endeavor to find out teacher of teacher of neighboring school who can be deputed in the school of the petitioner for providing local arrangement in terms of government notification dated 3rd January 2022 in order to facilitate petitioner's transfer. If school authority, stop. If school authority of petitioner has found a teacher of neighboring school, respondent number 7 shall also consider whether that teacher can be deputed in the school of the petitioner or not? Which deputed or not, whichটা কেটে দাও for transferring the petition. Stop. If teacher of another school is deputed in the school of the petitioner, comma, petitioner shall be transferred immediately thereafter in accordance with law. Stop. Read petition stands disposed of urgently. How it is possible? Whether DI will whether DI will be able to do it or not, nobody knows.
Uncertainty is also
No. It depends upon the willingness of that teacher. That is the main problem. Next matter. No stipulation of time.
Item number 189.
I'm appearing for school.
Issue. At the time of call, no one appears for the petitioners, and no accommodation is paid for. Next paragraph. On 7th August 2025, accommodation was paid for on behalf of the petitioners and same was allowed. Thereby directing the matter to appear in the monthly combined list of September 2025. Stop. Next paragraph. State respondents are represented by learned advocate. Next paragraph. You are for the board. The state respondents and West Bengal Board of Secondary Education are represented by learned advocates. Next paragraph. It appears petitioners have lost interest. Stop. Writ petition stands dismissed.
I'm appearing for school, your lordship.
You are for the
School, your lordship.
Oh, তাহলে এক কাজ করো, respondents are represented by learned advocates. Respondents are represent করে দাও, ওর কোনো specification এর দরকার নেই.
Item number 190.
I am for the petitioner, my lord.
for lordship.
190. No. Yes.
But Miss Kolpita Pal is appearing for the state. But I have
Service notice.
I have missed my affidavit of service.
It's an old notice or new?
Old notice of February 2020.
Then serve notice. Because in that notice you will find that it is to be moved. Petition was informed to be moved before a different bench issue.
And that is of February 2020.
At the time of call, learned advocate representing the petitioner prays for accommodation to serve notice upon the respondent authorities to serve notice afresh. Stop. Next paragraph. Respondents are not represented today. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the learned advocates representing the respondents. Directed to serve notice upon the respondents or the learned advocates representing the respondents. Enclosing copy of this order by fortnight from date and file affidavit of service on the next date. Next paragraph. List the matter under the same heading for further consideration in the monthly combined list of November 2025.
Good.
Upon the respondents of the learned advocates representing. Next.
Item number 193.
Yes.
But I have applied before the board upon payment. Itself, till date, nothing has been done to our income.
Who are the, who are representing the respondents apart from board?
But I have served.
Old service. Old service.
Yes.
Because writ petition was filed on 9th February 2024.
The board is the appropriate authority.
But other authorities has to be served.
I'll leave it. Because I have on prescribed form and the requisite fees, I have deposited.
Very well, board is the contesting respondent. But so far other respondents, you have to serve notice.
Very well.
Issue. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph, line, accepting West Bengal Board of Secondary Education, other respondents are not represented. Next paragraph, learned advocate for the petitioner is directed to serve notice upon non-appearing respondents or the learned advocates representing those respondents, enclosing copy of this order by fortnight from date and file further affidavit of service on the next date. Next paragraph, list the matter under the same heading in the monthly combined list of November 2025. Next.
Item number 194.
I appear for the state, your lordship.
Petitioner herein has approached this court for the fourth time, your lordship. And
what about service upon the other respondents? Respondent was 6. School authority.
the state is the answering respondent.
But you have to serve notice. It is an old service filed on 13th February 2024.
Kindly give a direction to.
Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph, learned advocate for the petitioner is taken on record. Next paragraph, apart from state respondents, other respondents are not represented. Next paragraph, learned advocate for the petitioner is directed to serve notice upon the non-appearing respondents or the learned advocates representing those respondents, enclosing copy of this order by fortnight from date and file affidavit of service on the next date. Next paragraph, list the matter under the same heading list the matter under the same heading in the monthly combined list of November 2025. Next.
Grateful.
Deeply obliged.
Yes. Just in this, let me go through the order. Yes, instruction. Commission was directed to obtain instruction. Why? Because it is in the supplement combined monthly list. Once it is not taken up, it will not be taken up for the rest of the month. Where is he?
It's online.
Here, pass over. Pass over. Next matter.
Come back anytime, my lord.
Item number 196.
Wait.
Wait, I'll wait, I'll wait.
This is my application. In terms of your lordship's direction on 7th August 2025, I have again, my lord, all the respondents, they have received and also including the learned advocate for the state. Mrs. Sujata Ghosh is appearing on behalf of the state. This is the affidavit of service.
Have you served notice?
Yes, it's all.
Where is the affidavit service? What you are praying for?
In this twofold pair in this repetition, my lord, some amount has been deducted from my as an overall amount after my retirement, and consequently the pay scale has been reduced, though they cannot do it since the pay scale was fixed in terms of the High Court's order. They have complied. Approval also given them the DI in the year 2015, and after retirement, they are saying that this scale is not to be given to you, sitting as the appellate authority of this court.
Please place the facts.
Yes, ma'am. Initially, petitioner joined in the year 1997.
When petitioner retired?
Retired, my lord, on my lord 30th November 2020.
30th
November 2021.
Yes.
And
where is the pension payment order?
Yes. Pension payment order, page 57. Last pay scale, 68,000. It should be more like 70. In terms of the last scale of payment. And since the petitioner not issued the pension payment order, under their instruction, they have refund the amount. On documents, your lordship kindly see the page 36.
1,37,134 was refunded.
Refunded.
On 17 January 2020, when it was refunded?
24th January 2022. Page 56, the Treasury Journal. Page 56.
Yes, 24th January 20. Why you have refunded it? Why you have not approached the court at that point of time? You refunded it, got the pension, and now you are challenging it.
No, my lord. Until and unless I refund this amount, but the PPO was not issued.
So at that point of time, you could have approached the court that this demand is wrong.
So they have asked that.
First you refunded, got the pension, and now you will, no, that is to be refixed appropriately. Esho.
But the
affidavit of service filed on behalf of the petitioner is taken.
Kindly see the page 36, my lord. Page 36.
Petitioner retired on superannuation on 30th November 2021. And while processing the pension case of the petitioner, state respondents found excess amount was drawn by the petitioner. Demand was made by the state respondents to refund excess drawn amount, and accepting such demand, petitioner refunded excess drawn amount on 24th January 2022. Thereafter, pension payment order was issued on 14 June 2022. Stop. Next paragraph. Petitioner prays for direction. Petitioner prays for refund of alleged excess drawn amount, which petitioner had to deposit for getting pension. Stop. It is also submitted that fixation of pension has not been made in appropriate scale.
My lord. Page 54, my lord.
Appropriate
scale. Their observation, page 54.
Next paragraph. On submission of the on perusal of the writ petition, it appears that petitioner is in receipt of on perusal of the writ petition, it appears by issuing pension payment order dated 14 June 2022, admissible retirement dues were paid to the petitioner and petitioner is receiving pension regularly. Stop. There is no scope for passing interim order at this stage. Next paragraph. Let affidavit in opposition to this writ petition be filed by 2 weeks after ensuing pujafication. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging evidence. Next paragraph. Learned advocate for the petitioner is directed to communicate this order to the respondents or the learned advocates representing the respondents by 7 days from date and file further affidavit of service on the matter.
Therefore, affidavit of
Call the
service
pass. Yes, that I have recorded. Call the passover matter.
kept on the record.
Item number 195.
Call the passover matter. Where is the commission? Yes, where is Dr. Patru? He has come. I've noticed it. On correction, petitioner described herself as not para-teacher. Now, court directed the commission to obtain instruction. What is your instruction?
Now, while editing, the candidate inadvertently erased the para-teacher statement. Chairman is saying that he is to go by the final call, because that is the statement of the petition.
Then petitioner will not be treated as para-teacher.
Will not be treated as para-teacher unless there is a direction from the court.
I know.
Because we have to go by the candidate's own statement.
Where is such statement?
In the edited form, that is.
Page 34 is the edited form. I had inadvertently, my client had removed the word para-teacher, which was originally there in page 31. That is the.
Why she has done this?
That my lord, I can't improve my case now, but this is while editing, she has inadvertently removed the word para-teacher after she has submitted. Now she can't edit anymore. That is the.
Where is your initial application?
Page 31. Page 31, the words para-teacher is very much there.
While correction was permitted, then damage done.
Severe damage.
Yes. Where you have stated para-teacher, page 31.
Page 31, my lord.
Yes, at the bottom, para-teacher. Present scale of post of help pay para-teacher. Then is there any other column apart from 2 lines from the bottom?
2 lines from the bottom. That is
the only space where the applicant is required to disclose her status as para-teacher.
My lord. She had disclosed initially, but somehow she has missed out while correcting.
Then where is the correction made? Inadvertent correction.
Inadvertent correction, my lord, page 31. In the madhyamik marks, she had inadvertently written as.
No, while as as Dr. Patru is submitting that when at the time of editing, this was done. Now, where it was stated that petitioner was not described as para-teacher, where is that document? After incorporating correction,
page 34. Page 34, my lord, will see the word para-teacher is removed.
Burial on payment of rupees 10,000 rupees cost to the petitioner, by the petitioner, not to the commission, but with the.
No, that is not the issue. Thing is that this editing was done on 9th November 2016. Then the entire selection process has proceeded, treating this
But
candidate.
still selection process is alive. Court is hearing other those matters.
And there will be other candidates also who have made certain mistakes after during editing. Come back to court. There are several in court also. Para-teacher, this case, editing.
Initially, petitioner described herself as para-teacher, while chance was given to correct the form, correct the why this correction was required, why this opportunity was granted to the candidates who applied for.
Bishop was receiving various representations from candidates that they have made certain mistakes.
So you want to be treated as para-teacher.
We opened it for editing purpose.
But a petitioner participated in the selection process.
Everything will be subject to verification. Even when
But in that selection process, there was no written test.
No.
Only academic.
State weightage.
State
plus
weightage,
academic.
academic. State weightage is a state qualified candidate.
Yes.
State weightage, academic, and then personality test.
So, but the para-teacher status will also be subject to verification.
Yes.
The fact that she is para-teacher, she is claiming to be para-teacher, that is one thing.
So the verification will be made at a time of.
That stage is also over. We have completed our verification. We are now arguing so that we can start the personality test. But verification can be arranged. I am not saying it, but it is checking of the documents. So that part can be
So
done.
personality test is still left.
Yes, 10% para-teacher. That
Personality test is yet to be held.
Yes.
So then, if it is not held, then let the petitioner be permitted. If petitioner is found to be para-teacher.
Yes.
So I will direct the chairman to permit her to appear before him, and on production of necessary documents, if petitioner can substantiate that she is para-teacher, then treat the petitioner as para-teacher in consideration of petitioner's first application, which is at page 31.
But kindly, though it will not actually help me, record that this is being passed in
Under the special circumstances.
because there are many other candidates I know who have done similar
Mistakes.
Even in those bunch of matters, if I remember correctly, which are fixed, there are few candidates who have made this mistake.
But it is a case where petitioner will not be treated as para-teacher in view of correction incorporated in page 34.
No, due to correction, their teacher status has been
Erased.
That I think there are some.
But they are pursuing their remedy by filing the writ petition. If ultimately court passes an order or takes a stand, express its view, in that event their case will be covered.
That is why I am worried that this order will give some mileage to other candidates who have made the same mistake during the election. That is my only concern. Not one single candidate.
Several other candidates have made similar mistakes. Let it retain its position in the list in the monthly combined list of December, because court is hearing the batch matters relating to para teachers in connection with first SLST 2016 upper primary para teacher. So if any decision is taken by this court, this will govern this writ petition.
That I bow down to your lordship. Only thing, in the meantime, if
in the meantime nothing is happened, everything everything depends upon the outcome of those matters.
With liberty to mention if
not yet personality test is held. The first personality test, then panel,
We
and
have
then council.
verbal assurance that we will not hold the personality test without the leave of the court. For that purpose, it is now being heard by the court.
Simply I am adjourning the matter, because otherwise in those matters similar relief can be claimed by the petitioners. There are other similarly circumstanced candidates. Once those matters are decided, then the decision may have a bearing so far this writ petition is concerned.
Right.
Issue. Hearing of these matters stands adjourned in view of pendency of issue Now, in view of pendency of other writ petitions relating to first state level selection test 2016 within bracket upper primary within bracket para teacher. Stop. List the matter under the same heading. List the matter under the same heading in the monthly combined list of December 2025. Because I don't think that it will be concluded in this. It won't be possible, perhaps. Get it. Great.
Already fixed the kind of.
Yes, day after tomorrow it is fixed.
Whether available
Before vacation, it will take time.
before vacation.
I have to give preference to motion, but subject to hearing all of you on Thursday.
Item number 197.
97, my lord, I am for the petitioner. Thank you, Lord. My lord, order dated 11th of August, I was directed to serve upon the unrepresented respondents. State was represented on that day, but I have served.
Yes, have you completed service?
Yes, ma'am.
How many is there?
State was there on the last occasion.
Last occasion state was there, but when you have completed service?
But, it was served on them on 6th of
8 September 2025.
Yes.
Page 16, it is 8 September.
Yes, madam.
4th September. Let it retain its position. Let it be in the next monthly list because 2 or 3 days back service is complete. Issue. In terms of order dated 11th August 2025, affidavit of service is filed on behalf of the petitioner and same is taken on record. In spite of service of notice, respondents are not represented. This the matter under the same heading in the monthly combined list of November 2025. Next paragraph. Next paragraph. Learned advocate for the petitioner is directed to inform the learned advocate representing the state. A learned advocate for petitioner is directed to communicate this order, or learned advocate for the petitioner is directed to serve notice upon the learned advocate representing the state respondents by fortnight from date. Next.
Item number 198.
Lordship had given liberty to them to add the, yes.
My lord, I'm appearing on instructions.
198. Yes. For the petitioner.
Yes, who is for the petitioner?
My lord, I'm appearing on instructions. Mr. Shundip Das is appearing in this matter. He's on his legs in a different courtroom.
Yes.
He's on his legs in a different courtroom, my lord. If my lord kindly passes over the matter or grants me a day's adjournment.
You are appearing in this matter along.
No, my lord, I'm just appearing on instructions.
At the time of call,
Lordship, may I make one submission? Lordship, I have received instruction, your lordship, that she has received the pension payment, your lordship.
the Provident fund has been paid.
Yes, your lordship.
But where is the pension?
Yes, the Provident
Final
fund has
payment
been
of
made, your
Provident fund
lordship.
of rupees.
The pension, your lordship, is not being able to pay it because she has not given the documents, your lordship.
Yes.
She has not given the documents, your lordship. There is another instruction
That has to be
effect.
considered. Because the prayer is made probably for release of pension.
Your lordship, liberty was given to amend the cost title and add the school authority, your lordship.
To issue pension payment order and release pension, arrear pension gratuity. And the payment is made towards
Provident fund. Already, your lordship.
At the time of call, accommodation is paid for on behalf of the petitioner. However, state respondents are represented by learned advocate. Next one. Let the matter appear under the heading motion in the monthly combined list of November 2025. November 2025. Yeah.
Item number 199.
For the petitioner. Yes.
My lord, the petitioner wants, my lord, the full house rent because, my lord, as per the government circular, petitioner lives, my lord, the more than 50 to more than the 50 kilometers and thereafter 150 kilometers from his internal house.
Prisoner
Lives more than 50 kilometers and 150 kilometers from the maternal house. That's my lord, your lordship kindly come to your
petitioner pays for house rent.
yes, my
The
lord.
house rent he is not, petitioner is not
He is
getting.
paying, but my lord, the less house rent he has been paying. My lord, he has to pay the full house rent. That is the main.
Why less is being paid?
Uh, that has been, my lord, it is regarding, my lord, the petitioner husband is also, my lord, a government servant. That's why, my lord, it is mentioned if the place of the working place of the petitioner's husband and petitioner is more or less than 50 kilometers, then, my lord, the half house rent or the house rent should be paid. But if it is more than 50 kilometers, then, my lord, he has to pay the full house rent. That is the circular. My lord, I have also annexed the circular here on. My lord, your lordship kindly come to.
Yes, yes, yes.
My lord, 25, page 25, the first memorandum.
Take me to the relevant memorandum.
Yes.
Yes. Page 25.
Yes, my lord. First one. The first one, my lord. It has been.
No, I don't want first second. Which was the which is the circular which comes in your aid?
26A.
26A.
A.
Is it a case that the petitioner and her husband are staying
Yes,
at a
different.
distance more than
Yes,
50 kilometers?
Yes.
So which part of this memorandum is relevant?
My lord, your lordship kindly 2A 26B.
2A.
Yes, 26B 2A.
Yes, yes.
After careful consideration. Well,
That the distance is more than 250 kilometers.
So you are relying upon 2C.
Yes. My lord, your lordship kindly.
In case of distance is less than 150 kilometers, but not less than 50 kilometers, and the said distance is not commutable. So who will decide whether it is commutable or not?
I have already, my lord, I have made resolution before the headmaster.
It's a question of fact.
Yes, my lord. Your lordship kindly come to my
Court cannot straightway
27
come to a finding that the
No,
distance
no,
is
I
not
am not saying so.
commutable.
My lord, the resolution has been taken by the managing committee. That was also annexed with the petition. And my lord, that on the basis of that resolution, the headmaster has already, my lord, informed the DI to take a decision in this regard. My lord, my lord, letter that has been annexed with page 31 of this petition. The headmaster of the school has been written to it on 27th September 2022, which has been received by the office of the DI.
Page 31.
Yes, ma'am. And 31A, the type copy.
So who is getting house rent amongst the husband spouses? Who is getting house rent? You are receiving,
Yes,
or your
yes.
husband is receiving?
I am receiving, but that is a less house rent. I am getting
Yes.
full house rent. That is my.
Where husband is working?
Post office.
Post and telegram. He is not drawing
He is
any.
in Goria.
He is not drawing any house rent allowance.
that document is not annexed.
Nothing has been annexed.
Nothing has been
To
annexed.
that effect, nothing has been.
Whether he is drawing house rent allowance, where you have stated.
My lord, because of my lord, if the distance is working place, then the 1%, the petitioner should get the full house rent. That's why, my lord.
I am
because-
asking that whether the husband is getting any house rent allowance. Because it says, please read 2A, full HRA as per rule will be admissible to only one of the married working employees if the husband and wife stay together irrespective of distance. Only one will get full house rent allowance.
Yes, madam.
If husband and wife stay together.
Probably, my lord,
But the said amount of full house rent allowance may be divided in such proportions as opted by the said employees. The house rent allowance may be divided.
Yes, my lord.
If
If
opted by the
12,000, that will
employees.
be 6,000.
If opted by employees, one will get, if they stay together, irrespective of distance,
Yes.
one will get full. Otherwise, what is the next option, or what is the other option? That as per option, it can be proportionately divided between the husband and wife. Since you are not drawing the full allowance,
Yes.
then it appears that your husband is drawing a house rent allowance. Otherwise, you would have been entitled to get the full house rent allowance.
তাহলে কি করবো?
We are contemplating two situations, Mr. Day.
E and D.
A and C. 2A and C. 2A says that irrespective of distance, if husband and wife stay together, then one will get either full house rent allowance or it can be divided between husband and wife.
Yes. And
One. Now, other situation is delineated in C, where it is said that if it is less than 150 kilometer, but not less than 50 kilometer, in that event, both husband and wife will get full house rent allowance. If the distance is not commutable, that is the situation you are trying to, you are praying for getting the benefit of 2C. Now the question remains in connection with 2A that
it is
that petitioner is entitled, when petitioner is not getting full house rent allowance, then your husband must be getting house rent allowance. Otherwise, petitioner would have been eligible to draw full house rent allowance.
Yeah, the case is probably 2. Your lordship 2.
First, answer the query of the court. What is probable case that will consider by this court later on.
My lord,
You are saying that you are not getting full house rent allowance.
Yes.
Now, today, authority is not considering that distance is non-commutable distance. Therefore, both the authorities are, both the husband and wife are entitled to get full house rent allowance.
Yes.
You are trying to, you are praying for extension of this benefit in favor of husband and wife. That will be considered, that issue will be considered by this court.
Yes.
But prior to that, court is asking you, since you are not drawing full house rent allowance, in consideration of the provision as contained in 2A, clause 2A, if you are not drawing full house rent allowance, whether your husband is drawing house rent allowance, must be. Otherwise, you would have been eligible to draw full house rent allowance.
No, my lord. If you, yes, my lord, I understand.
So, where is the statement that your husband is not drawing house rent allowance?
Only para 11 is said that is working as
Yes.
in a post office
My
and
lord,
residing in Calcutta.
my lord,
Nah,
husband
only
is living separately with the
Only
wife
that.
because, my lord, the husband is in Korea.
That is
And my lord,
immaterial. That is immaterial. Court will consider whether 2C can be applied or not.
2D.
But in terms of 2A, any of the spouses is entitled to get full house rent allowance. You are saying that you are not drawing full house rent allowance. Then question arises whether your husband is getting full house rent allowance. How many occasions I will ask the same question to you?
That is not stated.
Either answer is not with you or you are not understanding.
Lord, I am understanding. Your lordship's point is if both of them proportionately give.
Yes.
That is your lordship.
Then why unnecessarily wife will draw a portion of house rent allowance? She will draw full. Yes.
Earlier, my lord, he has been given full house rent.
Where you have stated that husband is drawing nothing.
আর্লিয়ার কেন বিয়ে হয়েছে 22-এ 22-এর পর থেকে তো চাইছেন 22-এর পর থেকে ডিসপিউট হয়েছে
Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner is a teacher of a government-aided school. And it is submitted that petitioner is drawing part of house rent allowance, not full. Since her husband is working in post and telegraph department. So, it is not averred in the writ petition whether husband is drawing house rent allowance or not. Next paragraph. Leave is granted to the petitioner to file a supplementary affidavit disclosing the post held by the husband and whether husband is drawing house rent allowance or not. Stop. If husband draws if husband draws house rent, whether husband is drawing the full house rent or a part of it. Stop. Let such affidavit, let such supplementary affidavit be filed by 10 days from date and copy to be served upon the learned advocates representing board, representing West Bengal Board of Secondary Education and the state respondents. Next one, list the matter under the same heading for further consideration in the monthly combined list of November 2025.
Item number 200.
But I have retired in the year 2025, 30th September 2050.
Academic service. How school was served?
Definitely was
There is no acknowledgement.
but really it's a state.
No. But I have to satisfy myself. The service is complete. And yes, last occasion courts specifically directed.
Earlier served on.
Where is the service upon the school?
I do not have.
See the position. And the last occasion also state did not appear. Today also state is not appearing. Who is Somnath Ganguly, Mr. Boisho? So he never appears. So then last occasion, if state respondents would have been represented, court could have directed the state to obtain instruction. Otherwise, change the advocate, engage somebody else. It is in the monthly list. How long this will continue? What you will do? You will appear in this matter. I will direct the government period to regularize your engagement. So very good. You appear in this matter. I will direct Mr. Boisho to obtain instruction in the meantime. And serve a notice upon the school.
Mr. Boisho is not required to obtain instruction. He resumed order is the instruction. It's point of law. That's what I'm saying here. I will give a copy to the point of law. Point of law and one more thing I just required, Mr. question
Yes,
so that
yes.
we can also think over it. Matlab, I was given postgraduate scale of pay in 1982, appointed in 1981, retired on 13th September 2015. After that, they say postgraduate scale was to be given after 5 years. Not irrespective of law, can it be done after 35 years?
No, postgraduate scale of pay, whatever you
I'm
have,
saying, matlab,
whatever have been released in your favor, that cannot be refunded. Because you are protected by paragraph 18 of Rafiq Machine.
matlab, that's
But
illegally.
fixation of your pension, that has to be decided based on the decision to be taken by the by the state authorities, whether it is correct decision or not.
That's one rider I'm adding. That was done 35 years my initial career. Can it be revised now?
So today you are receiving pension?
No.
Nothing.
Nothing. And the second point, matlab, subject.
When you have retired, 2015.
2015.
So nothing has been paid to you.
That's controversial. And I was given on the basis by the DI, nothing suppression, that this is a teaching subject.
This is a
Teaching subject. I was appointed as a teacher in geography. It's a social science group. I got matlab, MA in history immediately after appointment. I was all throughout given teaching subject as history, social science group. So he preferred the initial ROFA, that is a teaching subject. Now, after 35 years of service, can it be withdrawn now? Even Malar Rafiq Masi says, if something done in
No,
the
if it is
meantime,
paid, it cannot be refunded back.
that's Malar. I am also Malar fixation of pay also.
Fixation of pay has to be decided, Mr.
That's what Malar.
Instead of sending the matter for hearing on affidavits, let me first apply, consider Mr. Sannal's submission, and also you take instruction in the meantime. And let a service be, yes, he is absolutely, Mr. Sannal is absolutely correct that the school has nothing to say. Who has passed this order? Commissioner?
Yeah.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. In spite of service of notice, respondents are not represented. Next paragraph. Mr. Boisho, learned additional government pleader, is present in court, who is requested to appear on behalf of the state respondents. Learned government pleader is requested to regularize engagement of Mr. Boisho on behalf of state respondents. Next paragraph. Mr. Boisho is directed to Mr. Boisho shall be at liberty to appear along with a junior of his choice. Stop. Learned advocate for the Mr. Boisho is let instruction be obtained from the state respondents. Let instruction be obtained from the state respondents before the next date of hearing. Next paragraph. Learned advocate for the petitioner is directed to complete service of notice upon authorities upon headmistress and secretary Midnapur Collegiate School being respondent number 5 by fortnight from date, and an affidavit of service to be filed on the next date. Next paragraph. List the matter under the same heading in the monthly combined list of November 2025.